Listen in and have your say. For our passion is true crime. So don't you take a little time to hit subscribe and ring that bell and smash that like. You might as well. For the record, come on in. Stories that make your head spin. For the record, come what may. Listen in and have your say.
Good morning.
Good morning. Good morning.
Good morning. Welcome.
Good morning.
Welcome to For the Record. And I think Steve has his potty mouth on today.
Yeah.
Excellent. A game.
Yep.
I like it. All righty. Well, did everyone watch this trial? Everyone up to speed? I did put a link. Good morning, Elizabeth. Good morning, everyone. I did put a link for a quick recap if you wanted to catch it in chat. So hopefully you took advantage of that. Good morning, Anna. Hello, everyone. Is it Deanie? Morning, Deanie. Lovely to see you all. Who else have we got in?
Yep. Good morning. Good morning. Let's see here. I think we got
Christine, good morning.
Elizabeth. Yeah. Deanie, Anna Pekarski. Good morning, everyone. Welcome, welcome, and thank you for showing up here. So, I'm assuming everybody obviously
Hey, 10.
has an idea what this case is about. Because this trial was going on. What was it? A three-day trial, Jody?
Yeah. Well, the fourth day was pretty much just
fourth day was jury deliberation. So it was a short trial.
Yeah.
Long deliberation, short trial. So Jody, I want to know what's your opinion on this case?
I'm in two minds. I am erring on the side of the jury did get it right, but I say that with tongue in cheek because there is room for doubt. So in my mind, it's the most reasonable answer, but it's not proven beyond a reasonable doubt.
Mm-hmm. So what was the strongest piece of evidence for you that
the blood
you
spatter
say makes it reasonable?
The blood spatter on the walls where they showed that there was both of the children's blood on that wall and that their heads would have had to have been in close proximity to one another when the weapon was discharged. And I didn't take into account the height. I did take into account the trajectory, because in my mind, if they're trying to place that gun in the child's hand, as an 8-year-old boy, I would think that, cowboys, Indians, you've got the gun in your hand, you're going to have it pointed away from you. And, that first time it discharges, you're going to shoot yourself. Especially if you've never fired a gun before as an 8-year-old. Especially if it hits your sister first. Yeah? You don't go back and keep pulling that trigger 3 times again, because she had 3 to the head. Yeah? I think there is a possibility of the actual ricochet theory to him, perhaps.
Well, have you considered, so have you considered, think of this situation, right? What we know is the parents were fighting. By the statement of the father, he says, according to the statements he gives to the police, that the mom was in the house. We know the mom's purse was found in the closet. It was never collected as evidence, but we know there was bullets, and we know there was a holster that was found with fragments of that holster found in the bed where the boy was. We know the boy's DNA was found on the trigger and the handle. So consider this for a moment. Mom, dad are fighting. They're arguing. Mom comes into the bedroom to hide out with the kids. The young boy wants to be a hero. The father's coming in. He grabs dad's gun. Dad's coming in angry and enraged, and he starts firing. And the bullets ricochet. And like you said, yeah, exactly. He got shot. That's why he shot himself. He shot his sister too. And
so you're saying all the bullets were ricochet?
Well, I'm saying you're firing 5 bullets in an enclosed space. We don't know what's going on. Now, here's the problem. You want to say, well, there's trajectory, right? In order to get trajectory and to have that crime scene broken down, let's talk about the disturbance of the bed, because the bed is very important, right? The mattress. The mattress was basically destroyed because they opened it up and they found the bullet, which indicated
Yep.
the positioning of that bullet would have indicated ricochet occurred, right? Next, there was the Mandalorian bedding, right? The comforter that was moved all over the place. We know that the bedding was moved because we saw on the we didn't see it, but it could be seen by the jurors that when they came in to render aid to the little girl, they moved her off the bed and they moved the bedding. So the bedding was disturbed. In order to get a trajectory pattern and to say beyond a reasonable doubt that this is what happened. Now, again, I acknowledge.
That body should not have been moved there because
Well,
you can't, can you?
the body was moved because you're going to put first aid above evidence collection always to save the victim. But the fact that it was moved should have rendered doubt on trying to repiece together that crime scene. It's impossible to do so in some cases, and sometimes it's not. And the problem we have here is that if the sole evidence is trajectory, which is opinion evidence, and we know the crime scene was not pristine, it was not in conditions that we could say can allow us to fully 100% beyond a doubt rely on that breakdown.
Mhm.
So we're left with what else? Well,
I only went on the trajectory of the bullet through the skull, like not the one into the bathroom or anything like that. Just purely that it was from front to back and up to down, like that. And there was only the one dent in the wall, wasn't there? The ricochet. With the bullets, I know one was lodged in JJ, but I missed where because she had 3 bullet wounds to her head, Jayla. Were they all still internal? Like,
hold on one second. Let me find out here.
I can't remember what the medical examiner said. Where they retrieved them from. I was trying to watch 3 trials at once.
Give me a moment here. I will have an answer for you. Because like I mentioned, I have databased the entirety of that trial. So we're working on that right now. I will get you, and we can go back and find the testimony. And
yeah, I know it was day 2, the very last, third last.
And the timestamp, it just takes a minute here because it's got to go through all the files. But point of the matter is that what we're talking about here is eliminating doubt here, because they're like, and again, everybody says, well, it could have been, we don't have to say it was the boy, but what we know is the mom is absent from the picture. What we don't know is how the gun was brought into the picture. What we don't know is why. I mean, like, this is what's so, nobody thinks it's strange that there's a purse and a holster found in the closet. The police fail to collect the holster because they think, because the father, like, you have to understand here, this was a mistake. This was a case where the police didn't properly investigate because they believed it was, again, remember, if you go and you listen to the if you listen to the explanation by Michael Gavitt, by the investigator Gavitt, he says, why didn't you GSR test the family? Because the dad said it was an accident. There was no need to, right? There was no need to. And those sibling says the
it just wasn't at point blank.
Yep. Hold on one moment here.
I was going to say something else too, and I forgot. Hello, Carson.
Yeah.
I'm going to stop streaming at 3 o'clock in the morning. My brain's mush by then. Oh, I was going to say, are they going to find pieces of the holster for the next 6 weeks, just in case? They're going to go back and check.
What's that? Check the holster?
They're going to check the bedroom for pieces of the holster to miraculously turn up for the next 6 weeks.
Well, I mean, that's the problem is like they should have thoroughly investigated this thing and they should have
I was
taken all
making
the
a reference to
statements.
Karen.
Yeah.
And
Well, yeah. Well, right. That's, that
that's
is,
how ridiculous it is.
it is. It is. I
Yeah.
mean, and that's the problem here in this case is an example of he should not have been prosecuted based on the evidence that they had, in my opinion. This was a prosecutorial discretion. So in the children's bedroom, the evidence markers in the children's bedroom indicated several suspected holes. There were 6, 8, 9, 10, and 11 were placed on the top bunk bed. Evidence marker 5 was on the bottom. Hold on, we'll go through here. We'll
There was
take a look at
5
this.
bullets shot though, wasn't there? 5
Well, here
projectiles.
I'm gonna put this up here in just a moment. Once it gets done, it's generating a whole thing. Trust me, it's got so much information. Let me just share this here really quick.
She was Elizabeth. She was going to testify, but the defense chose not to call her because they believed that she was just going to assert her Fifth Amendment right
Correct.
on the stand
And,
anyway.
and also she has marital privilege, so she wouldn't have been able to testify about marital communication.
We don't have that in
She
Australia.
could only testify to what she saw, and if she was alleging she didn't see anything, there was nothing
Yeah.
she could be.
Well,
There's nothing she could
alleges
add.
she heard the gunshot and ran out the house.
So
Didn't realize thinking it had
right,
come
and
from
they
somewhere
wouldn't
else.
have been able to make her testify about any type of. Here it is, right here. We're gonna pop this up. So I don't know if you can see that, Jody, or not, but
No.
we'll walk through here.
Can you make it any bigger or not?
Yeah, I can make it a little bigger here. And we're zoom in a little bit here. There it is.
There we go. Oh,
Okay.
this isn't what you sent me, is it?
No, I just did this search in real time.
Oh,
So
wow.
in the children's bedroom, the evidence markers in the children's bedroom indicated several suspected bullet holes. Evidence markers 6, 8, 9, and 10, 9, 10, and 11 were placed on the top bunk. Evidence marker 5 was attributed to the bottom bunk. So any questions you think of, we can ask more, but we're going to go through what they said about this. Crime scene investigation, page 1. Testimony, page 1. Deputy Jason White reported finding a little girl in the top bunk with a bullet hole in the center of her forehead. The prosecution argued that the bullet holes on Jayla Bass's head were aimed precise, deliberate bullet holes, including shots to her cheek, her temple, and her forehead. That's in the closing argument.
Yeah.
Wall and bathroom trajectory. One bullet clearly went through a wall into the adjoining bathroom. A hole to one of the walls where the bullet clearly went through, and you're going to see that it did go through, and it goes into the bathroom and the adjoining bathroom, and it goes through that bathroom and into the wall, and they're able to obtain that projectile. That's the state's opening. Shannon Bader, a crime scene investigator, documented damage where a projectile came through the bathroom wall that shares a wall with the children's bathroom.
Yep.
This damage is where the projectile came from of the B2 in the bathroom that shares the wall with the children's bedroom. There was damage labeled as damage A1 and damage B2, with the latter being in the bathroom that shares a wall with the children's room. Bullet trajectory evidence. The prosecution argued that based on the trajectory of the bullet holes and the lack of stippling on the wounds, the shooter was at least 2 to 3 feet away from the children, was likely standing on the outside of the bunk bed, was likely taller than 5'5", and was pointing the weapon downward towards the children. There was evidence of a bullet potentially impacting the mattress after hitting damage B and deflecting. If it had impacted B and deflected or coming ricocheting back, it now is coming in a direction back towards the direction it came from. And that's why it's located further into the side of the mattress away from the wall. That was in Clay Hobelman's testimony. The jury ultimately considered the trajectory evidence in their verdict. The only person that could have fired these shots in that household was him based on the trajectory of the bullets. And projectiles were recovered from both the wall and from the victim's body during autopsy. There was one other projectile recovered from an autopsy from whose body Jayla Bass's body. And crime scene investigator Robert Durr was present during the autopsies when the projectiles were removed. So this information provides an overview of the bullet hole locations. So
What about the boys, JJ's trajectory? I don't remember that one.
Okay,
Because
let's ask that.
that's still lodged. They couldn't retrieve that, which has caused him some. He's got facial paralysis, I think, on one side. They said, and, some learning difficulties.
All right, so it's processing. So as soon as that's back up, hold on. As soon as that's back up, I'll pop this up again. So what that is I've been able to put the entire transcript of the trial into a database, guys. And what it's doing right now is it's processing that. So any questions you think of, chat, let me know. And we could ask it, what was the defense? How did the defense handle this? It's going to be able to go in, dig in, look. It takes a little while because
so you have to load the database first.
You have to load the database of documents. You can load everything. I mean, you can actually load the entire case. This is meant to be used by a defense attorney during a trial to very quickly, utilize police reports and things and jump in and say, what legal, you could put a police report in here and say, what legal issues can I raise? And it would be able to go through and do this analysis. So anyways, it's coming through with our analysis. So we'll go ahead and start taking a look at it. Well, it's an extension of Chat GPT.
Okay.
Yeah, so it's actually one, if you go into Chat GPT.
Yeah.
And then you go into
so it's still a Chrome extension.
Well, no, it's not a Chrome extension. It's inside Chat GPT. So the Chrome extension would be like accessing Chat GPT or however you access Chat GPT. And then it's a GPT built inside Chat GPT, which is meant to, it's called AI Drive is what it's called. And it's the extension inside of Chat GPT. So here is the trajectory of the bullet that hit JJ Bass. So location of gunshot wound. JJ Bass was shot in the temple area on the left side of his head. Deputy Adam Rahman testified that JJ had what appeared to be a gunshot wound to the left side of his head. Crime scene investigator Danielle Janicek confirmed the wound. We have the injury to JJ on the left side of his head right above his ear. Trajectory and positioning. The prosecution argued the shooter stood outside the bunk bed. He then stood on the outside of that bunk bed, put his arm up and over the railing and fired at his children as they lay sleeping in the top of the bunk bed. He shot his son, JJ, in the temple, causing severe injuries that he still suffers from. The prosecution claimed that the trajectory suggested the shooter was pointing it downward. Again, we already know all this. 2 to 3 feet, 5'5" position. He had some struggles. He was incapacitated in a hospital room and was not awake and alive. And you could see the obvious wound to his head. JJ has no memory of the events. And in summary, he was shot once in the left temple region of his head. The prosecution argued that the trajectory was downward with the shooter standing outside the bunk, firing over the railing at the sleeping children. While the precise angle of entry isn't explicitly stated in the available transcripts, the positioning described by the witnesses and state's arguments suggests a downward trajectory from someone standing beside the bunk bed. So we're going to ask, did the defense raise? There we go. So it is, like I said, again, if you notice here, it's just not known 100% of anything. In fact, they're saying both kids were up in the top of the bunk bed, but they have no confirmation of that. They're relying on, I think Jermaine Bass's statement that he said both kids were on the top of the bunk bed because that's how he was wanting to explain an accidental discharge. But remember, he's trying to make the police believe this was an accidental discharge, which we all can agree it was not. So, as I said, when I was talking during jury deliberations, if we determine that that statement is worthless, and it is, okay, then it doesn't match with what we know probably with what occurred in that room, it's worthless. So all we can ascertain from that statement is he's covering up something. Now the question becomes proving beyond a reasonable doubt what that is. And I don't know. I think the defense didn't do a good enough job breaking it down in that way so that the jury understood, like, this is what we're saying here. But again, when you're involved in the case and you only have so many minutes, they do it the best way they want to do. And a lot of times you get in that tunnel, because again, remember, they're fighting like the stuff that they're seeing in there. They're humans. And I mean, you saw that in real time in the Ty Tucker case when he went out and addressed in his closing argument the nefarious things that Mansfield was saying about his wife and
just to
all
raise
this
that
stuff.
emotion level.
And then he didn't even focus on getting into the heart of the case and the reasonable doubts in the case. He spent like the first 20 minutes upset about that, So so the defense challenges, here we go. I asked it a question. So these are the way the defense challenged this. So the defense highlighted critical inconsistencies. So see if this sways you at all. In the medical examiner's report regarding the bullet trajectory, Dr. Noah Riley testified that the trajectory described in Dr. Mayowan's autopsy report was incorrect. The report had documented a slightly downward trajectory, but Dr. Riley testified that it was actually slightly upward. When asked about this discrepancy, Dr. Riley said the report is in error. If you look at all the measurements of the entrances and exits, it makes a lot more sense. The wound path is upward. So how do you feel about that, Jody?
The wound was upwards from where was the entry and exit? Or where was the...
Correct. It was upward, not downward. That's what Dr. Noah
For
Riley...
JJ.
No, for the little girl.
So from the forehead or the temple,
that upward. It was upward. So it would have been coming from someone coming from below the bunk bed. Inconsistencies in the crime scene documentation. The defense pointed out errors in the crime scene. Shannon Bader, a crime scene investigator, incorrectly documented which bunk bed, top or bottom, contained evidence. The prosecutor even acknowledged this error during closing arguments, stating, "Don't ignore the strongest and most compelling evidence of this case because the crime scene investigator wrote bottom bunk instead of top bunk. She made a mistake." So think about this, Jody. She was moved off of the bunk, right? So if evidence was found in the bottom bunk, what if the little girl got moved to the top bunk after the shooting by the father, because we know things were getting moved around, and he realized the little girl was dead and the son's there, and that's why he moves on to the son to try to get him help.
But wouldn't there have been blood spatter and
remember, they tore apart the mattress. They tore apart the mattresses. They moved the Mandalorian sheet, and they couldn't tell where it was all at, and they put the little girl in the top bunk. Because remember, he was trying to make it look like it was an accidental discharge to cover up what really happened. Projectile recovery location. The defense argued that Shannon Bader made a significant error in documenting where a projectile was recovered. She puts in her report on property receipts, and she says in her deposition under oath that the projectile was taken from the bottom bunk mattress, which they told you they can do, but they did not do. So
that was the bottom mattress they got that projectile, not the top.
Well, that was the problem. She changed it. In a deposition, she said it was the bottom, but then she changes it at trial and says it was the top to meet the state. This is what I'm saying.
Why didn't the defense recall these witnesses and go again, re-question them?
Because it was all brought out to the jury. You can't recall them and ask questions that have already been put on the record. The judge won't let you do that. The defense emphasized the limitations of the expert testimony regarding trajectory. Inability to determine shooter position. When cross-examined, Dr. Riley admitted, "I cannot tell you who pulled the trigger. I cannot even tell you where the shooter was." Dr. Riley also confirmed that he couldn't provide opinions about the positioning of where Miss Bass was, or the positioning of the shooter, or the firearms. Inconclusive evidence about bullet path. The defense questioned Dr. Clay Hobelman about the certainty of the bullet path conclusions. When asked about the damage to the wall labeled damage B and its relation to the mattress, Detective Hobelman admitted that he couldn't definitively tell this jury that damage occurred from this case because it wasn't lined up with the mattress, because they disturbed the mattress, and so they couldn't say what was going on. Regarding a theory about a bullet hitting a wall and ricocheting into the mattress, Hobelman acknowledged that it was an interference in an opinion rather than a definitive conclusion.
The jury must have put a fair bit of weight on it then.
Yep.
On
Now
that
that
opinion.
part is not correct. They have me as the judge because I put my video of the verdict in there where I was expressing my opinion. So as much as I would have loved the judge to have done this is me. So I mean, when I first saw that, I went back and I said, "What? I don't remember that." And then I realized, no, that's me.
It was you.
So let me let it know again because it did this to me the other day when I was. It says,
Go for it, Christine. Type it in, and we'll put it in.
So to clarify that, the judge is a host of a show giving commentary. Please adjust. Jeez. Yeah, you got to just constantly always keep it smart. But I mean, I thought when I first saw that, I remember I was looking at it, I was like, holy cow, what?
I wouldn't mind uploading Proctor's testimony into that.
Well, no, that would we can go back and do that because if we have it from YouTube, all I got to do is take YouTube transcript, put it into a text file.
Yep.
And I can upload it in, and then we can take that. And then the most important thing is having that entire first trial database, because then we can take immediately the other trial. And then again, if a defense attorney understands this, if your case is being televised, you can go on YouTube. You should have your paralegal going in and capturing every testimony like we're doing, and then taking it and putting it into a database and cross-checking that database with the previous trainer, because they have their transcripts. What this would be,
that can pick up any inconsistencies as well.
Yes, and then what this would be doing is for them, they could order the entire transcript of that last trial and have it loaded in here, and in real time, they could have a paralegal sitting back there snipping the trial.
Same testimony as last?
Well, they could be snipping the trial in 20-minute increments.
Yep.
Putting the videos up, just create a YouTube and do everything privately, and snipping that and throwing it into the database, and it would be instantly comparing everything against it and giving you cross-examination points. It would be identifying legal issues, identifying now you've got to use your own knowledge because it can make mistakes, it can make stuff up, but the real meat and potatoes is what it can do is a real-time comparison, and then give you a good idea of what question you should ask and say, okay, compare this to the previous testimony of Trooper Proctor. And they say, oh, well, he said this on this date, blah, blah, blah. And you could also have the preliminary
technical data as well, like the phone.
Well, not only that, but you would also be able to take the preliminary hearing testimony and evidentiary hearing testimony. You can have it all loaded up and instantly be in court, and you hear him say something and you type it into your computer in court, and it would give you the transcript and give you the quote that you would immediately have up in front of you, and you could take your iPad to the witness stand and ask them questions and put the answer. Does this refresh your recollection? That on? No, I mean, that's what this is. This software I'm using, that's what it's designed for. It's designed to help you comb through evidence, which normally would have taken an attorney hours to do, organizing it in binders and having to memorize it, put it to memory, and be aware of it, to where now if you learn how to workflow with this, if an attorney does that, they can be moving faster than the speed of light, and they can get this can win a case. Okay. This can win a case, and this can hold people accountable when you're not doing what you're supposed to be doing. And it's a significant thing.
If you've got a question, Christine, type it in chat what the question is so that we can put it into the AI database.
Yep, absolutely.
And anyone else who has any questions, knock yourself out.
For certain.
So did you have to download the software, or is it behind a paywall?
No, it is behind a paywall. Yes, I am paying for it. But I'm on a free trial right now. So I'm determining you get a 7-day free trial, and after that I have to pay $147 if I want to keep it.
A month? For a year.
No, it's for a year, but
Oh, that's
but
right.
that gives you like 20,000 tokens or something. I don't know. And I don't know how many tokens I'm using for all this stuff, but I figure if I max it out in 7 days, I'll figure out whether it's a good value or not.
Yep.
Now, I think the way it works is like if you were a lawyer, you could then do a like for your team. So you could assign this to several different people on your team, and for $20 a month per team member, you get access to the to the token limit of whatever it is of 20,000, however much that comes out to. And so I think the idea here would be a law firm would have to buy in, just keep buying heads at the table for $20 a month, which, in some cases it might be worth it. For me, I mean, I'm trying it out right now because it's pretty neat, but why did he use the gun on the kids? Well, that's the point, Christine. We don't know why. There is no reason why given. The reason why right now that's on record by the state, and I'll ask this to confirm. What is the state's theory on motive?
While you're doing that, I'll go through the DNA evidence on the gun, shall I? There was JJ's DNA on the firearm.
That's right.
Which the most significant evidence is the presence of his DNA on the grip and the trigger of the gun. Yep. According to Danielle Weinstein's testimony, JJ's DNA was found on the grip and trigger. Statistical value was extremely high. The defense attorney, that's my problem. When I get the DNA evidence, people, my brain just goes,
oh yeah, it's hard
too
to
many
follow.
Octillion, bajillion, zillion, fajillions. Look, forget it. Just tell me if it was his blood or not. I can't. I zone out. So I miss all of that shit. Prosecution's explanation. The prosecution acknowledged that JJ's DNA was on the gun, but argued that it was through transfer. I've no doubt that JJ touched that gun, or that some fluids from JJ in some manner or another transferred from the hands of that man onto that trigger and onto the pull trigger and the grip. The gun holster in the children's room. The empty holster was found in the child's bassinet in the kid's bedroom. Why would you go back with the gun? Like, I know I asked you this earlier, but it still doesn't make sense to me. If either you or your son have discharged this firearm and there's both children are injured, it doesn't make any sense to me. Like, how many bullets does that hold, that weapon in the magazine?
I am not sure. Let me see if it
because that would be the last thing that I would do, would be put the gun over into the master bedroom without rendering aid to the kids.
Well, here's the thing. Again, we don't know, and this is the problem. What we're doing is speculating, and we're not, and we don't know the answer to those questions, because what we don't know is what actually happened.
Yeah.
So what that would indicate is a responsible gun owner would say, get the gun out of, like, something happened in that bedroom. Okay. So here's what this tells me. Something happened in the bedroom, and somebody left that bedroom and secured the firearm away from that bedroom, because whatever was happening in that bedroom, there was danger.
But
so he secured it away from that bedroom. So what that tells me is there was something going on in that bedroom. Now, we don't know what it was. What we know is the mom's purse ends up in that bedroom. We know the purse was never collected. No one asked the question about what purse the mom had that night at Ruth Chris. No one went back and asked if that was the purse.
So that could have been, like,
again, like I said, what do we know that was going on here? This guy gets in the car and is jealous.
Yeah.
And clearly is thinking this woman is with another man. And he follows her to Ruth Chris, follows her car, pulls her over, and realizes it's her sister. He says, have you been drinking? And she says, it's her sister driving. You think that woman ain't mad now? What the hell are you doing, Jermaine? Why are you pulling me over? Why are you doing this? When that woman comes home, she's hot. She's mad. She's pissed. So when she comes home, shit breaks bad. We don't know what went on in that household. We don't know how they fought. But we know that there was a domestic problem going on. And what we know is that a firearm got brought out.
All right.
2
hang on.
kids got shot.
We need to stop.
Oh, okay. I
It's
got you.
11 a.m.
Yep, no problem, no problem. And yes. So why do we need to stop, Jody? Actually, I'll tell the story. So, guys, everybody, we're going to take a brief break here because this is a very sad moment, but it's an important moment because it was this time last year. I was broadcasting live. I was just going live right now, and I was talking about the Hannah Gutierrez case and the hold on one second. So I was talking about the Hannah Gutierrez case. I was doing the intro, and my phone rang. As many of you who have been involved with a live with me know, Rocky rang, and you'll see me if you go back and play that. It was day 6 a.m. session. I used to do 2 sessions because I had to break it in 2, and I looked down, and it was my dad's friend calling. Now, my dad's friend had called me before about other things. He's like an older gentleman, and he had phone issues. So at first, I thought he might have been calling me about some tech issues. The second call comes through, and I'm like,
I'm going to take this.
well, I still continued. And then the voicemail comes through, and you see me look down again, and you see me look away because I see the voicemail where I'm seeing him say, Steve, I'm at your dad's house. It's not good. And then I end my intro, got off the phone, and right now I'm finding out that my dad died. We're breaking down the door. We're going into his house and figuring out that, unfortunately,
At 11 a.m.
At 11 a.m. And then, well, I got over there. I had Connor with me. I had to get him secured with my mom and head over there. So within the next hour and a half, I'm heading over. His friend's going in, but right now I'm introing. I'm getting the phone call. So it was a year ago today that we lost one of the co-founders of the channel and the big one and the brains of the operation. So we just want to take a stop for a moment and just kind of recognize this moment of silence. He's still with us. He's sitting up here right now because we still have not yet.
Get him down.
We have not yet. Well, what I'll
What's
do
his
is
name?
his name is my name, Steve. So what I'll do, actually, it's probably easier just to do this than try to bring this whole big box down. But I'll just bring a picture down of him. This sits on the front of him. So this was Dad right here. You might see resemblance. I don't know. Some say there's a resemblance. But this was him at Easter, probably 2014. And this was if you look next to us, the rest of the family's all there. We were outside of a restaurant going in for Easter brunch. But he sits up here and watches over the lives for the time being. And eventually we're going to get around to spreading it because his parents were cremated. He was cremated, and eventually we're going to do a little ceremony up where we spread his parents. That's what he always said he wanted to do. But we've got to coordinate my sister coming in. She lives out in California, and I like having him here. It's good to have him right next to me. Watch over me.
Can I share a screen?
Yeah. So it's just
look what I found.
Just very, very, very sad. What's up, buddy?
Checking on that actually as we speak. Make sure the judge didn't misspeak. That's crazy.
Let's go through the order of trial for any of you that
How
have not
far
been
in?
through a criminal trial.
This would be day 6 in the AM at the very beginning.
Day 6.
Yeah, day 6. Yep.
I thought. Yep. Sorry, openings.
Yep. No, 6 in the AM. I had to go find it myself because I was watching it. That's just how I am.
Day.
Yeah, 6 in the AM. These are not in great order.
Day 6 in the AM. Yep, got it.
Yep. And you see me, and I'm literally doing it. We'll be sitting in this exact spot I am right here. Yep, you can see.
Okay, and then
rewind
how did
it
you
back.
end up transitioning?
Right at the start.
We'll see how this day goes here. I think we can take away from this situation, in my opinion, one of the things that you can takeaway here is this case has made the case on why you do not talk to the police. Why, under no circumstances, do you sit down, whether you believe you're innocent? Obviously, she brings her attorney to these to the statement, and I'm not sure what her attorney was doing there. I don't know why he allowed her to speak to the police. It absolutely made no sense to me. Why? Because she talked herself into these charges by answering questions, by giving them something to investigate. She talks herself right into the charges, and that
There it is. That breath
that is
right
a concern. That is a very big
I was
concern
reading the
because,
voicemail because
without having given the
Really?
statement she gave,
Yep.
they would.
Oh, I missed the phone ringing.
Well, no, the phone rings earlier. You got to go back, go all the way back, and you're here. But that was when the
she
phone rings
was,
twice. You're seeing me get interrupted.
responsible for
Right now,
moving things.
I was
loading
actually having a
things,
great
doing
day. I was on
things that,
time.
Hannah
I was
Gutierrez
getting ready
had
to.
responsibilities, et cetera.
Everything was lined up really good. And,
Again, as I said,
and
I've
it
this
felt
is
like
a
it was going to
simple
be a
case
really
that
good
I
day.
believe the state is complicating by just
boom.
bringing in too much stuff. I suppose maybe the state's idea here
Yes,
is, like
we
they
do.
said in their
Yeah,
opening,
we have similar
want to tell you
noses.
the
That's
entire
what I've been
story,
told.
so you have the entire
Really?
story in front of you.
My
and you
dad and I,
understand
yes,
where Hannah
yes.
Gutierrez fits in this. And
You
I
have to grow a
suppose at the
mustache.
end of this,
Yeah,
that would be
he
okay,
always
but the
loved. My
problem
son
is
has a
when you do
mustache.
that
My
and you do it
19-year-old.
through witnesses,
He's a clone
and
of
you
my
do it in a
dad.
long
Except he has
trial,
blonde hair.
sometimes the jury loses
And
fact.
he even has a
loses
mustache
focus
like
on
my
what
dad did.
exactly is
So,
going on, especially
he's-
in a trial
Hey,
as
Queen Olive.
nuanced as a involuntary manslaughter trial. Because remember, it's not an issue of, it's not a whodunit. It's a, this is the law. It's an otherwise lawful act that you're alleging that negligence entered the picture and made this an illegal act. So it's sometimes, in my opinion, and should be the approach that you want to streamline that, especially if you're the state, and say, okay, here's the deal. We know certain things happened, right? But what we're saying is this was the negligent behavior. This is what we want you to focus on. Otherwise, you put this big picture in front of the jury.
Like
the defense can then
there we go. Yeah,
argue
it should be coming here
opportunity
shortly
for them to bring doubt into the picture.
We can
And
hear
doubt originates
Rocky
from,
at 2
I can't really figure this out. I'm not really sure what they're saying. Yeah, you're right. There was a lot of people on the set. Can we say beyond a reasonable doubt that she was the one that was responsible? That causal link that has to stay with you from the act that the negligent act she committed to the actual discharge of the bullet can get muddy. They can get questioned. They can become.
You know what? I reckon if you had a Red Bull, that's exactly what you'd say.
Oh yeah, absolutely.
Source of reasonable doubt that the defense could argue to. So, my opinion is the state's playing right into the defense's narrative by presenting this huge, broad, long case, essentially bringing into things, telling this entire story, bringing in experts.
I used to be a huge fan of Red
weapon
Bulls.
was and proving that
There
Alec Baldwin had to.
And you see, I look because I'm like, now that's my first thing. Okay, I'll call him back in a minute.
Pull the trigger on this. They're making their entire case.
How can I do my phone? How can I do this?
His negligence was
how can I set this app up? So I'm like, okay, I'll call him back in a minute. No big deal.
You got different lighting as well.
Yeah. Yeah.
How long had you been on? How long has it been since you'd opened the channel?
That had been so that was February 28th. I opened the channel on November 3rd of 2023. So we'd been going for, I guess, what was it? December, January, February. We were coming upon 4 months.
Yeah.
And this was one of the, this was like the second, you figure, Ty Tucker was the first trial I ever covered, like from start to finish, and was broadcasting it. And then this, I think I did the Blake whatever trial. I can't remember his last name. It was he stabbed his girlfriend. And then in the Crumley trial, and then I think the Crumley trial, the first Crumley trial happened. I covered that. And then the Hannah Gutierrez trial had started during the Crumley trial of the mom.
Yep.
And then the dad was about to get tried because my dad and I were going to go on. I was going to bring him on because in the original Crumley trial, my dad was like a due process guru, and he was, he had looked at because it was an interesting case from the standpoint of how they charged that case, because the statute itself didn't cover technically how the theory of how they were trying to charge the parents. And there was a due process issue of the idea of that. How could the Crumleys have not have like they have to be aware of how you're violating the law to violate the law. So that was what he was going to come on and talk about. And the fact that this was ripe for a reversal, which we're already seeing, it's already working its way back through. And those are some of the issues that are coming up. And not to mention the immunity agreements, which are really prosecution agreements to testify. But anyways, that's for another day. We should cover that. But at that point, he was going to be coming on to talk about that. And we had him, this was the 28th, this was a Thursday.
Yep.
Today's Saturday. So today was going to be his debut. We were going to have him on, and my son was going to go over to his house and mic him up and help him through the process. And we were just going to probably, it wasn't going to be a great background. So we were just going to like get a good picture of him, and he was just going to be known as the Oracle. I was going to, let him talk. Cause you think I can talk? My God. And he would answer great. He, like I said, he used to go down to the coffee shop, and that's why he loved it. He would talk for hours with everyone for hours and hours and hours, and it would talk the law and help people and answer legal questions. And people started knowing he was down there, and they would come in, and then he got a group of young attorneys in the area who started knowing he was down there. And every Tuesday night they would go in and pick his brain. And then a couple of them, he started actually, like, they were like, hey, would you help me during a trial? And he said, yeah, of course, and basically it was, he just loved to talk the law and loved to help people with the law. And, that was the, that was the whole basis, was he was going to come on and start talking and educating, and I was going to, run the day to day, but he was going to be available to watch the cases, because I had it set up so he could watch the trials at his house on his TV
and give an opinion.
And then he could be giving, and he would be texting me, throughout the day. And I was going to also have him set up so that he could just call in, if we're alive, and say, hey, Dad, this is going on. What do you think? And he'd be able to talk,
Yeah.
So, but you know what? We had other ideas, so it is what it is. Unfortunately.
So did you just then, like, once you've had the phone call and then you've read the messages, you just
there's that phone call happens in a few minutes. You'll see, if you play it, you'll hear another phone call come within like 30 seconds, and then after that, you'll see the part we all saw where then the second call he left a message. And it says, I'm at your dad's house. He's not answering his door. Can you give me a call? And he was coming to take my dad to lunch. And he basically, anybody who knows my dad knows my dad doesn't not answer the door for lunch. And his Meals for Wheels food was out front, which is not normal.
Yep. We have Meals on Wheels.
Yep. It's Meals on Wheels, man. It might be Meals for Wheels. Yeah, I guess it's Meals on Wheels. But he had that. He got that, and he.
That was still on the doorstep.
Yeah, it was still on his doorstep, which normally he would always have his front door open because he'd greet the guy and talk to him. Yeah. The guy knew him, and he loved the guy. They would talk. Anybody that walked in my dad's house, my dad just had a bad habit too, of just leaving his back door open. I'd come in and tell him, what are you doing? Like, he said, I don't care.
I'm the same.
Ain't nobody coming in here to hurt me.
I'm not living in a fortress.
Yeah. So he would he loved the air to come through. Plus, so he would sit there with the back door open. You just walk on up and walk on in and say, hey, Steve, what's going on?
So you could get round to the back. So
you can't he was in a wheelchair
coming through the house.
Well, he was in a wheelchair, so he had a wheelchair ramp built to the back of the house he was in, and that was the only way he could come in and out, because he was wheelchair bound due to some just bad decisions he made, as well as health ailments. So he, at the end of his life, he was wheelchair bound, completely wheelchair bound, and he was he could get up and like maneuver himself, but he did not have the ability to walk without not any safety on his own. And he refused to go live anywhere. He didn't want to live with anyone, nor did he want to live in a home.
Yeah.
There's a whole story on that whole odyssey.
Oh yeah, I reckon.
And he was insisting he was going to live on his own, and that's what he wanted to do, and that's what he did. So, but his friend knew it was weird, because my dad got up. He liked to get up and watch the sports shows. He would get up at like 7 a.m, and he would start watching. He just had a whole thing of things he would do. Watch the sports shows, then he'd get the trial turned on if there was one to turn on, and he'd start watching that. Then he'd have clients or people that he was helping out that would come by and bring him donuts and bring him stuff to talk
Did he have
about
someone
cases.
to come and help? Was he not get him in the shower or?
Well, no, he did for a while, and he fired him because he didn't want him coming. And they called me, and they're like, "Steve," I said, "Your dad just fired us," and I said, "What?" And they said, "Why?" But he had life alert and everything, which he had there, but it didn't end up working in the end. But that was really also partly his own fault. But basically he did not have. He just was he wanted to have his independence,
Yep, I
for
get
a
that.
multitude of reasons,
Yep.
and he just that was just what it was. And like he said, he said he would rather pass on than live in a facility
Yep.
with artificial lights and everything else. And that's
Yep.
pretty much what he ended up doing. So I think that, I don't think, I think he was tired, I think, to a degree as well, because it had become like just daily, everyday little things had become very, very taxing. Like
Yep.
just going to the bathroom for
Yep.
him was a big deal. And,
Yep.
and going up and deciding to go make the cup of coffee. But he was
Yep.
insistent. He didn't want help. He wanted to make that cup of coffee, and he wanted to go do this, and he wanted to go do that, because to him, it was about the independent factor. Like he
Yep.
did not want to have to say, "I can't do it." And he would do it, and he would sit there, and it was painful sometimes to watch but
Yeah,
it's
I do,
just,
unfortunately.
so, but like I said, we respected that, and said, "Okay, Dad," I mean, at the same time too, it was like, "Hey,
How,
you got
how
the
old was
time to
he?
do all this."
How old was he?
He was 75, I believe, right? Yeah, 75, because it was 24. No, he was 75 going on. He would have been 76, so he was 75 years old. Yep. So he was like I said, he had he didn't do himself any favors in a lot of some of the choices he made in his life. So he could have lived. My grandfather lived to 93, his dad. Now his mom, on the other hand, was a lifelong smoker, and she lived to 73, died of lung cancer. So but she was as stubborn as he was, because
Yeah.
she refused to stop smoking even when she was, in chemo and getting her treatment for lung cancer. She was trying to
Yeah.
get my aunt to sneak cigarettes into the hospital. That's just,
Yep.
and she was a resilient lady. She did not
Yep.
take no.
Yep.
She figured out a way around it. There was
Yeah.
no. I can remember my grandfather and her, because my grandfather always wanted her to stop smoking, for her health reasons.
Yeah.
So they would make bets, like, "I bet you can't stop," and he would agree. It would be for $100
Yeah.
or something. And I remember we would come over, and Grandma would be over by the window secretly smoking, and my sister would say, "Grandma, what are you doing over there?"
You can't secretly smoke.
"Stop."
It stinks.
And Bernie would come out. That was my grandfather.
Mhm.
And Peg, what are you doing?
That's why I love vapes. They don't
Yeah.
smell. They're great.
Yep.
They're great.
And she so like I said, it was just it was just his time. But this time last year, I was getting ready to go through a very dark time. That was just a very sad time, because it was
Did you
and still is.
make
I
an
mean, it's still
announcement on the
getting
channel at all? Or
What's that now?
did you announce it on the channel?
My very next Justice Watch Live. At that time, I was doing my Justice Watch Live. Well, my goal at that time, again, I had a vision that it was like, okay, we're going to cover one trial, not 5. We're going to cover one trial. We're going to be watching it throughout the day, and there'd be times I'd be going mobile, and then basically we would all come back together at the end of the day at 9:00,
Do a
and
recap.
between 9 and 11, and do what's called Justice Watch Live show, which is the trial court. We get out of the way of trial court. We talk on breaks, but we let the court speak. We let you watch. And at 9:00, we talk shop, and we bring my dad in, and that's when we're talking. And sometimes my dad would, be on this or not. It just depended.
9 to 11. You limited it to 2 hours.
Well, that was a start. That was a start window. No, yeah. If you look back at some of them, we would go 2 to 3
Oh,
hours
yeah,
sometimes, and
yeah.
that was with maybe 1 to 2 people in chat. I was just talking to myself, uh, or I just get one person hooked in, and we'd be going back and forth. It didn't matter. I could talk and
Yeah.
talk and talk. Especially when it comes to a law or legal issue, I'd just be sitting there. But if you go back to watch that, we started out with that trial's set to go soon. It's the Kenneth DeWitt or DeWall, I think it's his name. He shot a police officer. That was the first Justice Watch Live we ever watched. But then it basically got derailed because we launched it and then my dad died. And then after that, I didn't go back for a while. And then I came back for
Yeah.
one. I think it was the Crumley verdict, but I pretty much took a little hiatus, and then I just never kind of launched anymore because it was kind of like back to the drawing board. So then it's been kind of just my podcast that I do for Justice Watch Live. Eventually, it's something I want to do, but it's at the same point too where it's just been. I also realized the ambitiousness that I had when you have once Connor Paul starts school and I've got this and that, and it's like, oh,
Yep.
well, 9:00, and then 9 becomes 10, and then 10
Yep.
becomes 11, and then my wife says, shut the hell up. What are you doing out there talking loud? Go to bed. And then it, all kind of falls on its face because it's like, well, I guess that isn't you can't just, it's not going to work
Not
out to do that
conducive.
every night. So
You don't have a set room that you can.
no, I don't. No, unfortunately, I
No.
do not. We have a set area of our living room that I do in, and then we have unfortunately, the playroom that we have is right off here. So that's why Connor Paul oftentimes does his best to yell as loud as he can to get into my podcast. And
You
then
can't abscond the playroom and take it.
no, the problem with that is the playroom, the way is where the Wi-Fi is at. In that playroom, it's an all seasons room, so it doesn't have the ability to run the Wi-Fi out there. And I want to hook into my router to be able to run everything as smooth
So
as
you
I
can't run a
possibly
cable
can.
out there.
No, well, I mean maybe I could, but I haven't even tried to figure that out yet. And then the other thing is, there's the only electric stuff is on one side of the room because the original person that had this house, this was actually where the all seasons room is would have been like the porch and the patio, and
Yep.
some of these
I built
houses
it
have
in.
decks. So, and then we have the kids' rooms, which are all occupied right now because we have 4 kids, and then we have of course, my room, my wife and I's room, and then we have the kitchen and the dining room. So in a way of our layout of our house is it's like a real open layout, which is real nice because it's always thriving with sounds and noises. But it's not great
Mhm.
for trying to podcast or trying
And
to have
I've
a
got the
conversation with
opposite.
people. Oh, you have the opposite?
Mhm.
Nobody, right? It's silent, right? Yeah.
Mhm.
So to me, which again, like I said, I mean, it'll go by fast.
The only
One day I'll
noises
be
in my house is a cat meowing, me snoring, or YouTube playing.
well. What I've thought about doing is trying to come up with figuring out I think I'm going to try to do something to where, well, we do this, so this is good. This is why I like to be able to come out and talk, but also figuring that I'm going to try to do something to where one of the main problems is obviously when the kids are at school, trials are going on, so
Yeah.
it's like I'm
Yep.
not going to do it then. So then by the time the trials are off, the kids are home from school and then we're in the
That's
middle
dinner
of
time, and it's
and that's
crazy
the other
time.
problem is okay, so a lot of times, dinner time comes up and, now that we're on school and I can't really justify being like, okay, well, we're not going to eat dinner till 10 o'clock because dad has to go and do his 3-hour podcast. I got to produce dinner and then I got to get bath time and then I got to lay down with the kids. And then by 10 o'clock or 10:30, guess what? Dad's actually tired because I've
Yep.
been up since 6 a.m, starting my process to run the kids all around and get everybody to where they're at. So then I'm like, oh man, I don't really feel like going live. And
You tried to
not
start
to
at
mention
1
that
a.m.
everybody else is sleeping too because everybody else
Yeah.
been watching trials all day, so it's like, if I went live, it probably isn't going to have a whole lot of people in there. So I just say, I figure I use the times within the trials, and baby Carson's going to be there. And if you're going to watch my content, you're going to get the kids too. That's just what it is.
Absolutely. Yep.
So
Yes, it is.
I've gotten a little better microphones that helps to not hopefully capture all of my surroundings. And we're do the best we can. But I mean,
Yeah.
this ain't no, we're not court TV. This is not professional.
No,
This is
no.
just
I had someone send me a comment today
Mhm.
on something, and they didn't like the sound of my voice,
Well, then don't
and
listen.
they stopped and made a comment.
Yeah, well, I mean, that's what I'm saying. I mean, like,
Don't like it, don't listen.
yeah, I mean, it is what it is. Like,
Oh,
that's why I figure, like we I try to do, to me, I just figure what I'm trying to do is get the content out,
yeah,
get the ability to watch these trials. I'm working on trying to refine the process of getting as much into a description as I can to help the description be an investigative process as well.
yep,
And, trying to, well, thank you, Deanie. I appreciate that. I know Deanie is in there on a daily basis hearing his kids when I come on, especially baby Carson right now, where he's
so
in
cute.
that he talks and talks and talks. He loves, and if he hears me talking, I think he thinks I'm
Uh-huh.
talking to him, so he's just going off. I mean, he's like, which is great. I love it. It's Oh, Elizabeth Caldwell, she definitely knows in 6 kids, yes. Like
Yep.
I said, yeah, you know my plight in the morning, although you're got a few more there than I do, and it is when you're lining everybody up, you're getting the baby ready, the 5-year-old ready, the 15-year-old ready. Used to have
Ah,
the 18-year-old here, and we'd be getting him up to go and make sure he was out the door, and it's just
they're
you gotta
often
have
harder.
and you got a lot of planning you gotta do, so
Yeah,
luckily my
I know.
wife helps with a lot of that, and but when she's working, she
Mm,
has to be at the hospital at 6:30, so
yep.
it falls on myself, and she'll set me up, but still, it's like walking out the door, and I can't. The one day
Yeah.
I walked out, and we left the lunchbox and the backpack after I'd gone around to all the
Mhm.
places, and I got to drop off Connor Paul, and I go to grab the backpack where it normally is, and I said, "Oh my god!" And of course, the
Shit.
teacher's like, "It's okay." I said, "I know, but he packed his lunch." And she's like, "Oh," I said, "Yeah." I said, "And I already told the front office, so he's not down."
Mhm.
I said, "So I'll be back."
I
So,
had a
it
two
was
and a
just
half
like,
year old
oh,
and a
yep.
4-month-old that I was breastfeeding, and I was nursing at the time. So I would get her up, breastfeed her, change her, get the 2-year-old organised. This is at like 4 a.m.
Mhm.
Off to childcare, go to work, express my breast milk during my, you know, breaks, and keep. Luckily, we had a special care nursery that had the electric pumps, so
Mhm.
I'd sit up
Oh,
there and watch Days of Our Lives and express on a
and
lunch break,
it
and then go back. And by the time I got back to the childcare centre, I was like so much milk. It was just like
oh.
I got to feed her in the car because I was in pain. I got to sit in the driver's seat like, oh, thank God. So she'd be choking on breast milk because I could have fed an army. Then I'd go home, cook tea, get them bathed, get them organised, and then I would start waxing clients at about 8 o'clock at night.
Wow. Yeah,
Yeah,
well, I mean, that's what you gotta do. You gotta do it all around the schedule of the kids,
yeah,
and, you gotta make sure they're taken care of
yep.
first, because I mean, they need us, they
Mm,
can't do it on their own, even though
no,
sometimes you forget that because you're like, "Oh, man," but they really can't. They didn't ask. They didn't
no,
ask to be
no.
here. We brought them here, so we gotta
Yep,
make sure they get to a
yep.
point of self-sufficiency. Now, when they get to be 15,
Mine are too
that is
self-sufficient
not
now.
well, exactly. Well, that's my 19-year-old. I mean, like,
Yeah,
I hear from him. He's in college. He's doing well,
yeah,
so as far as I know. And, look, yeah, I hear from him I hear from him when he needs me, and I
yeah.
take it when I don't hear
Once
from
there's
him, that's a
food
good thing.
involved.
Yep, yep. So
Mm,
so we have a
it's just
question in here on the case. Columbus, who is somebody who was a great contributor to great debate yesterday. Let's throw up the Columbus's comment here, because it said, Steve, you said Bass's statement that the shooting was accidental. We can all agree that statement was not credible. You said that statement was worthless. I disagree. That statement is not worthless. And then Columbus goes on further to say, It is a lie. Doesn't him lying go towards consciousness of guilt? Well, it could. It could. But Columbus, the other evidence has to arrange itself to prove what happened. What it does, what I'm saying is it's worthless in telling us what happened beyond the lie. It's worthless in telling us why he lied, because there's other reasons why he could have been lying. And I think you may have come in here late. I'm not sure if you saw the beginning part, but we went through a wealth of the evidence. So rewind back. It's worth watching. We went through a wealth of evidence that was presented in this case, which shows that things are disputed there, and that and also to answer your question, Jody, I found out it did come back at 6. It had 6 bullets in the magazine. So it means there was either one left or one had already been fired.
Yep.
Which, of course, if one had already been fired, we don't know. That was never really established. But the whole point of the situation is, Columbus, is that we don't know what context to take the lie in. And there's nothing to say that he, why he lied. You don't just say just because he lied. Well, why did he lie? He could have lied because
he's protecting someone.
He was protecting someone, right? The state has to disprove that beyond a reasonable doubt. So, yes, it could be consciousness of guilt. Yes, if the other evidence would be indicating that that's what happened. But here's the problem. Again, why is the mom's purse found in the closet? Why is fragments of the holster found in the bedding? Why is the mom not saying things on the 911 call like, he shot my kids, please get help, protect me?
Yeah.
She's not saying those things. That's very concerning. Why did she let him talk to the child after this happened? Why did she not
stay the fuck away from my kids? You're not going anywhere.
Although they can't argue that, but we can certainly look at it, and you would think the jury would have said to themselves, wow, well, why? And I think they did say that to themselves. That's why they took 7 hours. But I think at the end of the day, just like what Jody came in here with, just like what you're saying, Columbus, at the end of the day, they're relying on their memory. And unless you have AI software to take the entirety of the trial as database and remind us of what we saw, at the end of the day, after 7 hours of arguing, and maybe you're the 1 to 2 people holding out, you begin to be swayed to the idea that says, well, okay, he stood up. But what did we find out? Dr. Noah Riley totally debunks and adds doubt to the trajectory argument that Jody came in there with. He said it could have been upward. On top of that, we have the disturbances of the mattresses. We have the crime scene analyst saying it was all that she was collecting evidence from the bottom bunk, which means even if it was an upward trajectory of those bullets coming in, if the little girl was on the bottom bunk and they confused the mattresses where they move things around. So the point is, we don't know.
It wasn't
And
proved
there's
beyond reasonable doubt.
And the only standard here is, did they prove beyond a reasonable doubt that Jermaine Bass intentionally unalived his children that night? And the answer to that question, in my opinion, is no. And that's why those defense attorneys were so confident. And I think they thought they were going to walk out with a not guilty verdict.
Yep.
And I thought that they had a shot at it. And then when it was 7 hours on a 2.5-day trial, I understand, obviously, it's been disproven that the math doesn't matter, but it does show they struggled. And this should have been an easy case, right?
Yeah.
If everything we're saying is true, it should have been a damn easy case because, hey, we got the gun in his hand. But it wasn't.
You type into AI, is there any evidence that suggests that she may have been the shooter?
Yep, let me see. Oh, yeah, I can type that in.
I agree, Elizabeth. Yeah. Like she ran outside thinking that, well, she says that she thought that the gunshots were from elsewhere. She didn't think that it was the children. And at what point did she realise that? Like when she's on the phone to 911 with a neighbour, or I don't know. None of it made sense.
No, it didn't. And it certainly doesn't make sense that that he goes back to the house over a trip to Ruth Chris and shoots the kids and then doesn't shoot her, because if we're going to take that statement with any truth, he says she was in the room or in the house. She was in
where
her
the
room.
gun.
Where the gun ends up.
Yeah.
So my point is, the significance of that is the gun ends up in the room where he says she was.
Yep.
So by his statement, he would have gone in there and he lets her live. Why?
Especially
Why?
if she's the one that he's angry at.
Right. Well, because what I think happens is the purse ends up in the kid's room. How
From a
many
struggle.
times have you heard about, well, yeah, but think about this, right? The mom retreats to the kid's room to get away from the dad. The
Yep.
mom gets the gun out because she's in there, and the dad comes in angry because he's like, and they're arguing, and they get in a struggle over the gun. The gun goes off.
But her
And
DNA wasn't on the gun, was it?
it wasn't, and that's a problem. But perhaps, who knows? Or maybe he went in there with the gun and was wanting to go off her, and he shot the kids into, and maybe it's that sinister. Problem is, we don't know.
But she would have got up and testified to that, surely.
And then the other thing is, and then that would explain the downward trajectory.
Yep.
If he's got the gun, or the kid has the gun, says, "Give me the gun," and the father goes to grab the gun out of the kid's hand, and the gun goes back, and it goes off. Boom, boom, boom. And then it ricochets off, and it goes into that mattress. And if they have the trajectory wrong and it's going upward and ricocheting around, then the kid gets hit in the back, and that's why the kid's outside of the bunk. The little girl might have been in the top of the bunk, and the mom or the dad now grabs the son and realizes he's okay. And obviously there was some cleaning up, because he's going to take the gun and go, "Oh my God, the gun was in the kid's hand." So he takes it and puts it in the room, runs back, gets the kid, gets the son, or maybe the mom. I mean, I don't know. We don't
They
know
don't know
because the
who
mom was
shot
never
first, do
investigated.
they?
No, they don't know any of that. And no,
I
they
wonder,
didn't empty.
I wonder
Well,
if your
Tanya Hill, they
fingerprint
didn't empty the clip. There was one. There was
one.
only 5 bullets fired. The clip held 6.
I wonder if perhaps, we're just putting it out there, he had the son had the gun and it discharged once, and that bullet was the first bullet to ricochet and hit the son. Would that then perhaps cause his hand to
Go correct,
uncontrollably?
because he's trying to grab the gun out of the son's hand, and boom, 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 or the son's like, "Dad, get back," and he goes, "Boy, give me that gun," and they fight over it, and it causes the gun to discharge 5 times because they're fighting over it.
He had something with his pinky too, didn't he? Didn't he have
Yeah.
a shot?
Yeah. Yes. And then the mom is freaking out because that's why she runs out. "Oh my God, my kids! Oh my God, please get help! Get help! Get help!" Because
Well,
she
I
doesn't
didn't
know
think
where.
she was that.
Well, remember, she didn't. She goes to the neighbor. She doesn't use her own
Yeah.
phone because she didn't know where her phone
Yeah.
was, because where was the phone? It was in her purse. It had to have been. And then the
I thought she
father.
had the phone on her when the first
I don't know. I
time
was
she went in and out.
speculating.
They said,
I'll ask that question here.
yeah, I thought they said because when they showed the ring camera footage, it showed her going backwards and forwards, like walking. No, it wasn't an automatic or a semi. No, that was the first question I asked.
But the phone was never turned over to the police. We know that. It was never located. But my point is, we don't know. We know the phone and the contents of that phone have never been looked at. Never
But
been
they
looked
got
at.
his phone. And
They
would have
got
been
his
able to
phone
see.
and they found nothing on it.
Well,
There's nothing on it of any suspicion. The only thing they found on it was that he called his mother 1 minute,
oh, that's right.
a
Yes.
minute and a half after the gunshots rang out. He called his
There was
mom.
no deleted messages or phone calls or anything.
No, there was nothing.
Well, then what was the point of getting her phone? Because it would have been on his if she was arguing with him.
Well, she could have had messages about what she said to other people, about what she was doing, about text, about the fight that was arguing. Absolutely. Hers could have had a wealth of stuff on it. She refused to turn it over. She turned it over to her attorney and refused to turn it over.
Well, that was my
So it
issue,
says,
Tanya, too. Yeah.
so does not call her phone. She goes across and uses 911 to dial Mr. Evans' phone. She's on her phone with 911. You're going to hear from the neighbors, DeQuan Evans, who's going to tell you that he heard these shots. It woke him up. He walks out. He sees Shirley Bass. He's on the phone calling 911, letting him know. And you're going to hear that 911 call, and you're here. Yeah, she did have her phone.
Yeah.
So, but she chose to call the neighbors. So go answer that question.
Yeah.
That's weird as hell.
Yeah. And it wasn't like she was running. She was pacing backwards and forwards.
Because whatever occurred, in my opinion, occurred out of a domestic argument that went too far. The gun got out. This was not an intentional crime to where he killed his kids intentionally. And I don't think the defense ever believed the jury would ever think that. But, obviously the trajectory, which they missed the part about Noah, or they couldn't have missed it. The defense brought it up. But there it is. So let me pull this up here. Let me show you guys what I'm looking at right now. I don't think it'll let me zoom in anymore. No, it won't. So here we go. We're going to go. So evidence potentially implicating Shirley Bass as the shooter. DNA evidence on the firearm. Inconclusive DNA results on the magazine. Crime analyst Danielle Weinstein testified there was no determination as far as her contribution to the DNA on the magazine. Limited testing of the gun areas. While Shirley was excluded from the grip and trigger areas, the defense highlighted that testing of other areas was inconclusive. The defense expert stated the defense stated you cannot tell this jury that Shirley Bass did not touch that firearm. That was Danielle Weinstein. It wasn't the defense's expert, but it was Danielle Weinstein's cross. For the slide and sights, it was limited. It was a limited DNA profile, making it impossible to determine if Shirley had touched those areas. So there was a DNA profile, a third one found on that gun that was not able to be identified. Think about that for a minute. There's 3 people's hands on that gun. The child's, the wife.
Oh, there was 3 DNA.
Yeah, right. And there's a third person in that house. Who the hell else could it be? I mean, I guess they could say maybe it was like something from the cop, but a cop or something. But the defense highlighted evidence of a purse containing gun-related items found in the children's bedroom. A purse in a kid's closet, a magazine, holster, and .380 ammo was found in the children's bedroom. The defense emphasized this purse was not collected or tested. It wasn't printed. It wasn't swabbed.
And they did no GSR on anyone.
In dinner absence, Shirley was at Ruth's Chris restaurant for her sister Marlene Gadsden's birthday party, which Jermaine Bass did not attend. The prosecution established Shirley returned home shortly before the shooting, claiming less than 8 minutes later, you're going to see Shirley Bass outside looking for help. Frantic shots had rung out just a few minutes from coming home. Think about this for a minute. 8 minutes, guys. What am I saying happened? She goes in that house. They get in an argument. Her purse ends up in the kids' room. She's in that room at the time this happens. There's a struggle. The gun's going off. He's not killing the kids. There's a domestic violence incident that ends up in the kids' room because for some reason. Maybe it's because she goes in there because she wants to try to get away from him. And he's, pursuing her.
It was first degree they charged him with.
Well, because the theory on the cases that he went in, I mean, I don't understand how this jury even gets there with evidence they have.
That the intent was that
they're saying he went in and killed his kids for no reason.
The 5 individual discharges.
The defense emphasized Shirley's alleged lack of cooperation, reluctance to allow JJ to interview.
No, Danny.
She wouldn't let him. She wouldn't let him interview. Phone not provided. They were not able to investigate her phone because she never turned it over to law enforcement for them to look at any kind of communication that happened that night. 911 call behavior. Does not call 911 from her phone and goes across, and the phone that she is using to dial 911 is Daquan Evans. Lack of witness testimony. A stipulation was entered that JJ had no memory of the events. She didn't testify, and highlighted that she didn't testify, limiting the explanation. And then the DNA exclusion said that Shirley could not have done this. She's excluded from the DNA on the gun. She never touched the gun, at least not the grip and the trigger. So you see how the prosecutor did that? And this is where I have the wrongness of it. The prosecutor says, she tells the jury, and they understand what they're doing. That jury's hearing that. So what they hear is, oh, her gun, when they're arguing back there, they go, well, she couldn't The reason why he's guilty is her DNA was excluded. No, it wasn't. It was not found on the trigger. It was not found on the gun. There was other DNA profile found on other areas of the gun that were inconclusive. And not every area of the gun was tested as per the DNA expert. So it was not done. So there was questions about who was on there. So technically speaking, there were 3 DNA profiles found on that gun. There was 2 that were identified and 1 that was not. Her behavior afterwards is typical of a person who's just going through a serious traumatic event. Oh, really? Yes, it is, but it's not the event that you would think when you would think you'd be fearful of the guy who just shot your kids.
Yeah.
So the defense attempted to create reasonable doubt by suggesting Shirley Bass might have been involved. They did not present definitive evidence directly implicating her as a shooter. Instead, they highlighted inconsistencies, untested evidence in her behavior following the incident. The prosecution maintained that the physical evidence, particularly the trajectory analysis and Jermaine Bass's own statements about the accidental discharge, pointed solely to him as the shooter. And of course, as we all know, in Columbus pointed out yesterday, and we all know this, the state is not required to show a motive. They're just required to say, gun in hand, trajectory says he's guilty. We don't know why. He's guilty. Now, they were required to show premeditation. And what they were doing was they were trying to show that this had to be a premeditated act because he had to fire each shot. So premeditation can be formed in the moment.
Yeah.
So maybe the first shot, he just starts firing, but each one they're saying he had to boom, 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 boom. It's a lot of shots if somebody's actually shooting their kids. It makes no sense, though. So what makes sense, though, would be is a struggle, right? And maybe the 8-year-old boy's involved. Like, he's 8. He's going to jump in there. If dad and mom are fighting, he might have jumped up. And that's why the 8-year-old boy doesn't get shot. The little girl's up at the top of the bunk, and she gets shot. And that's why it's a somewhat upward trajectory, because if they're fighting and the gun's going this way and they're in the room, right? And they're struggling over that. First of all, the wife, depending on how it was, perhaps, who knows what the situation is, but what I think may have happened is they're fighting and their son gets the gun out, thinking like, get back, Dad. And then a struggle ensues over the gun. And then because they're trying to get it out of the son's hand, and it goes off, and then it goes off, and then it goes off, because, again, this was not a lot of pressure needed. And then the kid's shot, the daughter's shot, the mom runs out of the house freaking out, and obviously doesn't call on her phone, and that can be explained away.
I'm trying to find that. Was it day 2? That Ring camera? Or was it day 1 in the afternoon?
Well, Columbus, no, the cardinal rule is you cannot speculate, you cannot fill holes. But if there are holes which to speculate upon, that is the definition of reasonable doubt.
Reasonable doubt, yes.
So the cardinal rules for juries is, yes, you can't fill in these holes and speculate like they did to get here. They only got here by speculating and filling in holes, and they're not allowed to do that. We are allowed to say there are alternative theories, alternative possibilities that can't be ruled out. And for that reason, the verdict should have been not guilty. The fact that these questions still remain is not speculation that's inappropriate. It's appropriate questions. But what we should have seen from the defense was something like what Joe Tacopina presented today's Sat Broccoli jury. These are 10 questions the state can't answer, and you can't either. And if you can't answer these, you have a reasonable doubt. Boom, 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 boom. And if you can't answer these, this is legitimate, reasonable doubt. You only need one of them, and we have 10 of them, or however many they can come up with. That's very effective. And in this case, that would have been very effective. And made sure that they understood. Made sure that the state doesn't get away with the argument of, like they put on there, where they say, I've shown you and I believe and proved to you that Shirley could not have done this. She is excluded from the DNA on the gun. She never touched that gun, at least not the grip or the trigger. So they contradict themselves in that. And if they were to be called out on that statement, they said, well, no, what we were saying was it's not on the grip or the trigger. Well, no, it means her hand could be on the gun. There was DNA on the other ends of the gun. It means she could have been involved in whatever struggle occurred over that gun. We know there's a purse there, which means the gun was gotten out of that purse where the bullets were at. We know the holster was inside the kid's bassinet and a piece was inside the bunk bed. So somebody gets it out.
There's the holster.
Yep.
I'm trying to find the there's the purse.
Yep.
I'm trying to find the actual camera footage where she's.
Oh, go to I know which one that is. That's the
Day 2 morning.
No, it's hold on.
Because it was fairly late, wasn't it?
Yeah, it was the I have it. I can pull it up really quick here because I just recently put that up. Hold on here. It was
certainly wasn't day 3.
It was here. It is right here. This guy, Michael Gabbett. All right, hold on. Let me find it. Give me a moment.
What day is it? Do you know?
Yes, that would have been day. It was one of the. Oh dang! I didn't put what day it was, but I think it was day 3. It was like not day 3, day 2. It would have been the evening, either end of day 2 or beginning of day 3.
No. End of day 2 was the medical examiner and the niece and the sister.
Hold on, here we go. Because this is
testimony. Day 3.
Anyways. Here it is. I'll put it up.
That's the noise that scared the shit out of me before.
Prior to the call, the 911 call being received, and those 2 vehicles are going to be determined to be surely back. I observed the white Mercedes C300 leave.
I've got it now.
Okay, we're going to move through this because it's.
All right, here's where they walk through the entirety of
military time.
It's going to be 10 p.m. on
here
the
it is.
video.
This is when she arrives home and everything.
And which we know now is 10:11 p.m.
Correct.
Okay.
That's the truck arriving.
And he goes out first, doesn't he?
Yep, you see him.
In his trackies.
Yep. Now
Detective,
we're going
real
to
quick,
see
what
the
do we
whole.
see
This
in
is
this video
that's why this
for-
evidence is really
Hold on,
critical
just-
because it's.
Go ahead.
There it is.
Judge, I'm just going to object to the corporal narrating.
That's why I stopped.
Yeah, there's a bit of the ring camera footage in that angle that shows her walking backwards and forwards.
Oh yeah, it's coming up. But we'll watch this because this will be important. It's going to watch her. It's going to show her arriving too. We want to see if she has that purse when she's arriving. So here he comes. But yeah, you're going to see her pacing in and out right in here.
Now, Corporal, in this video, we see that truck that you had described earlier coming in. Was that the significance of this video?
It was.
And again, in watching that video, do you ever see any children or anyone get out of the passenger side or anyone else get out of the vehicle other than the driver?
Yeah, I wouldn't object to the corporal narrating the video.
Right, overruled.
I do not.
All right, I'm now going to the fourth one. That's labeled 8/30/2022, 9:09 a.m. All right, Corporal, what is the time on this particular video at this time?
It's going to be 10:18 p.m. with 34 seconds on August 29, 2022 on the video.
Okay. And what's the real time on that?
It's going to be 1 minute ahead of that approximately. So it's 10:19 and 34 seconds.
Okay. Okay, yeah, just leave it there away from here.
I think it's earlier. I think
Corporal,
once
just
you get
for
to,
Jerry, where are we looking at here?
You're going to be looking just to the right of that Titan, to the left of it in the video, but to the right of it physically to the vehicle, which is where Shirley
Here she is.
Bass's
This is her
Mercedes is
arrival.
going to pull back in.
So let's see what she has, if we can focus in that corner.
And Corporal,
Drive it
while this is
big.
playing, where is their front door in relation to where this video is?
It's just off camera to the right.
So somewhat behind that Nissan truck on the video?
Correct. It's in the video would be in the area behind the truck, sort of obstructed by the leaves of the tree.
Yeah, just leave it play through. Yeah, just come on. Now we're going to the fifth one down the line. Now what's the time on this one?
This is going to be 10:26 and 59 seconds on the video, or 10:27 approximately and 59 seconds in actual time on August 29th, 2022.
So this is approximately 5 or 6 minutes after we just saw the last video.
Compared to the last video, it's approximately 4 minutes at this time.
4 minutes, okay, thank you. So Detective, we've moved forward a little bit on the video. We're now at what would be 10:30, 37 seconds, or 10:31 in real time.
Correct.
Okay, thanks.
Looked like that must have been a DoorDash driver.
Yeah.
Looking all around, phone in hand.
I've got many of those.
Oh yeah.
On my Ring camera. Actually, I've got a really funny video. I should show you. Yeah, see, after
Here
this
she
it
is.
goes,
All right, there she is.
where is that? Why did I miss that?
Oh,
What
there it
time
is.
on the video
Detective,
is it?
it's now 10:33:10. We see an individual walk past. Did you ever
That's
identify who
her.
that individual was?
I did.
22.
Who was that?
It was Shirley Bass.
02, is it?
Yep. It's about 37 minutes in this video. The 10. Yeah. So that's her. You're to see her come back down,
Yeah, yeah.
and she'll be frolicking there for a minute
22.
as she
Can't
comes
see what
across.
that
But I'm, you know,
And Corporal, while this is playing, where the individual you identified as Shirley Bass walked to, the individual known as Daquan Evans who called 911, does he live back in that location where she was walking towards?
Yes, he does.
Okay.
and there she is. Does she have a phone? No,
Yeah.
she doesn't have her phone.
No.
Where? No, there's no phone.
She comes back out a few times, so.
Or freeze it. Hold on, I'm gonna make sure.
I want to see what, I can't see what the camera time says
There
on
it
the
is.
top.
Okay, there's no phone. Look, she's got no phone in her hands. She's got her hands completely empty. She's got no phone.
So go back, keep it going, because I think she does it a few times. She comes in and out a few times before she goes to the neighbours.
There's the
Where's the
DoorDash driver.
DoorDash?
Now, DoorDash has the phone. DoorDash oblivious to the whole thing that just happened. DoorDash
Yeah.
like, I'm getting to my next order. There we go. See?
Yeah,
no
see,
phone.
she's on the. It
No,
looks like
that's no phone. She got her hands up on her face like, oh my gosh, watch. You're see. And she doesn't have pockets. She doesn't have a purse. The purse is not there.
no purse. Did she
No
have it when
purse.
she walked in?
Well, you couldn't really tell, but I would imagine she did. I mean, she just came from a nice restaurant. And that's, that was her purse. She was out and about eating. See? Nothing. No on her hands. She's not looking. She got her hands together in praying mode.
But she doesn't look frantic either.
Well, she looks like she doesn't know what to do. She looks like she's like, oh my God, what has happened? What has just happened?
Corporal,
Is she not on the phone there?
No, she just got her hands on her face like
and
this.
it appears she has something in her hand. Is that correct?
Well, hold on.
That's correct.
And it's up to her ear. That's at the phone.
Correct. It looks like she has it at some point at her ear.
I think that's
and at some
Daquan's
points in her
phone.
hand, and she's looking
That's
down
Daquan
at it.
Evans' phone. Yeah, that's the phone that he gave her. Remember, he gave her his phone. So she does have that there. That's when she's making the 911 call. But she did not have her phone. When she walked by there originally, she had no phone in her hand at all. And you get a good clear shot of her hands, like when she's right around here.
While this is playing, where she called 911, does he live back in that location where she was walking towards?
Yes, he does.
Okay.
All right, here we go. I think she's gonna. The first time she walks through, we're gonna freeze it.
On
There
my
she is.
copy.
There she is. There she is.
No purse.
Nothing. No purse. No phone.
That's
nothing.
when she arrives.
That's
Is it?
No. This is when she's coming over. Her apartment's over here. This is when she's walking towards Daquan Evans' apartment,
Oh.
And there's her
Oh, I got it
hand, nothing
backwards.
in her
Okay.
hand, nothing in her hand.
No.
Look, nothing in
So
that
we
hand.
didn't catch her coming in
No, that was
from the car?
her car is here. Jermaine's car is here. Her car is here. He got out and went this way. She got out and went this way. In fact, if you look closely,
Okay. I
when she
thought
gets
the
out of
to
the
the left was
car,
the front door.
there's activity over here. So they're walking behind here. So if you look closely, you
Yeah,
see
yeah.
the same thing over here. The
Yep.
front door is over there. So she walks and goes over there. She's leaving from over there. No phone, no phone. And that phone is somewhere in that house because she didn't have her phone
Uh-huh.
because she just walked away from a struggle. So there is no phone.
Where she's dumped her purse in the bedroom.
Exactly. And that phone was eventually collected up before the police arrived. I think. I don't know, but it was not collected by the police, obviously. And she took it, and we don't know what was said, done, or what happened after the fact. All we know is here she is, and what she's not saying, what she's not doing. She's not asking for help. Wouldn't you
Yeah.
think she'd be running, help, help?
Yeah.
No, he's
Yeah.
a madman.
That's what I was saying.
She just
There's
left
no-
him in the house with the kids. Wouldn't you be saying, call 911, help me,
Yes.
he's got a gun, he's got a
Yes.
gun.
I would be going
She
spastic.
didn't do it. I mean, that's what should have been being argued. That can be argued. Those actions can be being argued, what she didn't do. I mean, and again, the defense did to a degree, but I'm saying that should have been on a big board, in a big thing and said, this is a question. This is a question. This is a question.
Yeah.
This is not, the state can't answer these questions. Now,
Detective, it's now 10:33:10. We see an individual walk past. Did you ever identify who that individual was?
I did.
And who was that? When you obtained it, correct?
And I think this is what
Corporal, we are now at 22:41 or 10:41.
There she is out there.
Which I guess would be 10:42. What do you
police.
see happening here in the corner up there?
This is capturing the arrival of the first law enforcement officer.
So she comes just before the door to
Shirley Bass's C300 is, and I believe that's Shirley Bass.
So here we go. So she leaves and returns to the apartment
All right, we have one more. This is the
before the
last
police
one.
arrive, and then you see her coming back out across. So they're in there altering that crime scene.
And what time are we at here?
This is going to be 10:35 and 26 seconds on August 29th, 22nd on the video. However, it's approximately 1 minute later also, so approximately 10:36 p.m. and 26 seconds.
You say 10:26.
Yep. Listen, this case, I guarantee you, will be pursued at some point from the Innocence Project at some stage because there's something wrong with it in a big ass way.
I was really enjoying my popcorn at that time. As I'm watching his meat.
Well, there she is. I think she goes back. I think she leaves. I just went back a little bit. Well, that's the DoorDash driver.
It appears she has something in her hand. Is that correct?
She got something in
That's
her hands.
correct.
Okay.
Points out at her ear, and then at some points in.
Yeah, I feel like popcorn. I'm watching myself eating it. Law enforcement rating.
Yeah, we have one more. This is the last one.
I guess we don't see her disappear because she walked off with the phone.
35 and 26 seconds on August 29th, 22nd on
This
the
is the
video.
law enforcement
However, it's
arrival.
approximately 1 minute later also, so approximately 10:36 p.m. and 26 seconds.
So he comes out after.
Corporal, we see an individual walking around out there. Were you able to identify who that
The
was?
very first time that she comes
The
out,
person at the far end or the
she's
person
not
closer
running.
to the tree?
She's not
Close to the
rushing.
tree right there.
I'm not aware if that person was identified personally.
And what do you say the person at the far end?
The person, there's a person walking around near the area where Shirley Bass's C300 is, and I believe that's Shirley Bass.
Yeah, there she is. So she must have walked off with, I think she walked off with Daquan's phone. Or we never saw him get it back.
22:32 is the first time she comes from the right to the left to go to Duquan's. And so he must have come out after, looking for her, yeah?
And he got the phone back because we see him with the phone in his hand. He gave her his phone and said, "Here, talk to 911."
No visible blood on either of them.
Well, unfortunately, with that black and white camera, it'd be difficult. But no, it doesn't appear so. No.
So
No,
this
but
is before
but
he's
there
gone
could have
into
been
red
splatter.
light.
Well, here's the thing: they didn't examine her, Jody.
This is before he's gone in and brought JJ downstairs then.
All right, Corporal, we are now
Well,
at
yes, I would assume
22:41,
so.
10:41, which I guess would be 10:42. What do we
He's
see
running all
happening here
around
in the
now.
corner up there?
This is
But this is 10:42.
capturing
You
the
figure this is
arrival
where there's
of
been minutes
law
of elapsed.
enforcement-
She's been
the
back
first
in
law
the
enforcement
house.
officers who arrived at the incident scene.
And do we see the law enforcement interaction with Ms. Bass at that time?
We do.
Okay. Yeah, I just remembered.
So there it is. Dispels the idea she had the phone in her hand. Further evidence, in my opinion, of the fact that she fled out of that area because her purse was the purse found in that room was the purse she had with her that night, and is in fact the purse. I mean, it shows that she came home. There was 8 minutes elapsed between when she arrived and when the gunshots rang out.
When she left the home to go to the neighbors, she wasn't rushing.
No, she was running out like, oh my God, oh my God, oh my God. Like, what am I going to do? Trying to figure it out.
No, the first time she went across the screen,
she
was just walking.
Yep. And she
So
was
that's
trying to
supposed
figure
to
out.
be after the gunshots.
That was after. Yeah, no, that was definitively after the gunshots. Yes, absolutely, based on times and everything. She's not screaming, help, help.
No.
Like I said, this is a problem. This is a problem. No, there is no ring camera of her entering the home. It's just her exiting the car. Her exiting the car and then walking back off behind the trees. There is none of them entering the home or exiting the home or any ring cameras collected near their home. So there we have it. So, well, Jody, we're coming upon the 2-hour mark.
Yes, and my bladder is definitely telling me that.
And
I'm over 50 now.
I was going to say I can tell you that.
Fell down the hill from there.
So, well, what,
Mm. Do you reckon
so
he might come out and make a statement later at some point?
I think again, this is a case that's going to be pursued, I think, by the Innocence Project at some point, because I think
Did
he's
you
innocent.
answer Columbus's question on? I was trying to cover up the fact that he attempted to kill his kids.
Steve, you said the question is why did he lie? I answered that above. No, I didn't say the question is why did he lie, or why did he lie? Well, yes, well, okay. The way you're phrasing it is not. I did not say why did he lie. I said the question. The question
Sorry.
becomes, what was he lying about? What was the reason for lying? And was it he killed the kids intentionally, or was it something else happened that he was trying to cover up, that he was involved in and everyone was involved in, but he was trying to cover it up? And the answer to that is we don't know. That's the problem, Columbus. We don't know.
Yep.
We do not know. And I think we've
We
definitively
may
proved
never
it. You
know.
got to go back and look at the beginnings of this video and see for yourself. But there's a wealth of evidence of not evidence of questions about the evidence.
There's enough doubt. Certainly.
And when you put Riley, I think it was Baldwin's testimony, the doctor, who says it was upward, and you've got the other crime scene research saying it was downward, and you've got people saying they collected evidence in the bottom bunk when it was, but then changing it to the top bunk to fit the thing. You've got the evidence moving around. You've got a purse in the house. You've got things going. We don't know. And is there but the thing is, the jury was.
Did she have a statement at all?
No, never. Listen, I'm telling you, here's what happened. There were jurors back there who had questions.
Yeah.
And I showed you the quote from the closing argument. And I guarantee you, if there's a juror listening at some point to this podcast, it will resonate with them, because I guarantee this is what happened in the jury room. There were holdouts with all the questions we had. There was someone in that jury room who said, no, let me tell you why. It's impossible. They ruled her out. There's no, mom's DNA wasn't on that gun. Oh. Yep. Well, they said it in the closing. Oh. And they got to rely on their memories. And the way the state said it, which was...
Has the gun been wiped down?
Well, the way the state said it was, there was no DNA. It was like, don't let this question. There was no DNA found on the trigger and the handle.
Don't go outside the scope.
But there was an unknown DNA source on other areas of the gun that they couldn't figure out who it was.
Did they do a buckle swab on her?
Yes, they did do that. Yes, they did
So
that.
they had a...
Yeah, she was forced to turn that over. Like, she didn't have an option on that. Yeah, that came out and they did that at the hospital later that night. But the point is, it wasn't definitive that there wasn't DNA on there to say that she wasn't somehow involved. Now, I'm not saying, I don't think this was intentional by anyone.
No.
I think this was a situation. This was a domestic disturbance. They got out of hand. We know the mom had the weapon in her purse. We know that purse ends up in the child's room, open. And we know that the little girl ends up dead. The boy ends up...
so you think she had the gun in the purse when she came in?
Yeah, I think she went into the bedroom and there's an argument and she has her purse and she's walking in. I think they're arguing. I think he took her phone because he thought she was cheating, because I think that's why he went after her. I think he takes her phone and they're yelling, they're screaming. She goes in the bedroom because, they're fighting, and she locks the door and she lays the purse down in there and maybe gets the gun out. But at some stage he comes in, because I'm sure, they probably had violent fights. I mean, they were getting a divorce for a reason. And they go in, and somewhere in all of that, a gun gets drawn. And again, what I think it is it's the little boy defending his mom and pulls the gun out of her purse because she lays it down in there and is in there like, kids, please. And the boy gets down and grabs the gun. And then she said, and then when he comes in, he's pointing it. And he may have even fired it once, which is why there's the ricochet that goes into the bottom of the mattress. And then they go to grab the gun, and the mom jumps on it, and everyone's jumping on the boy. And then at the end of the day, that's why the mom's out there, oh my God, oh my God. And that's when her reaction, I don't know what the F just happened. I don't know what the F just happened.
Do you want to watch the verdict to sign us out?
Sure. Yeah, I think we should
All
do
right.
that. Yes.
Here we go.
You have it pulled up. Let's do it.
I certainly do. Tell me if you can hear it.
All right, be seated. My understanding is you all have reached a verdict. Is that right? Yes. If you would hand the verdict form to the bailiff for me.
You're trying to do it, and I'm trying to do it. Ah! What
Right, the verdict form is in order. If you would publish the verdict and poll the jury, please.
Yes, ma'am. State of Florida versus Jermaine Lavonda Bass. Case number 22 CF 011717A, Trial Division 3, verdict form. We, the jury, find as follows as to count 1, murder in the first degree. The defendant is guilty of murder in the first degree, Jayla Bass, as charged. And during the commission of the offense, did the defendant personally carry, display, use, threat?
So he's got weapon enhancements. Yep.
Oh yeah.
Or attempt to use any
he's
weapon
going away for the
or
rest of his
firearm?
life.
Yes.
What do you think the well, it's Florida. Is it mandatory minimum life for first degree? Because they took the death penalty off the table.
He gets. I believe he gets mandatory minimum life. Yeah,
and it's just whether or not it's parole or non-parole.
I don't think there's parole for life in Florida. I'll ask. Let me see here.
Did the defendant actually?
Well, he's got that's the one count. Then he's got the attempted. And
yeah, they were more worried.
So they'll stack that.
Yeah, I think that they were more worried about his, for the purposes of sentencing. That's why they were like, the judge. Well, there might be some options, but they could always try to downward depart, but they're not going to in this case.
No.
I mean, in Florida, the downward departure potentials are,
only limited to Treehouse.
Well, yeah, but I mean, you can ask for him, but it's very infrequent. And in a case like this, where the jury has accepted that he intentionally shot his kids, you get life.
That's what I meant. First degree.
Yeah, you don't have any. There is no other option. I mean, there shouldn't be, except for my opinion. I think every life sentence should have parole potential, because
otherwise
that encourages that the prisoner have something to live for, and encourages their good behavior within the system. And they should always, in my opinion, be living in remembrance of whoever it is they harmed. So by just throwing them away with a life sentence just seems to me wasteful, even though some would say, well, they deserve to be punished to the top of their, the worst possibilities. Well, I agree, except if I got killed, I would hate to think that my life was, that the individual that stepped in place of me, all they ever did was just live a life sentence. Do something good. Help somebody.
Hello.
Oh, hello. Nice little kitty.
I have a visitor. Hello, princess. Alrighty then.
So yeah, there are no life sentence. There is no parole for a life sentence in Florida. Only way you would get that is if you were sentenced before 1983.
Yes.
And it costs Florida $330 million a year because of that law. to house these people. So you're telling me there's not a way to deal
It's more
better
to be
in a
on
better
death
way?
row, though.
Yeah. Well, I mean, there should be
They
some
only took
form
that
of
death penalty off a month before this trial, too.
yeah. Well, they do that a lot because of strategy things and different things that can make the case drag on longer. And in this case, I think they also wanted to not. They figured that the jury might be more apt in this case to convict if it was facing life and not death.
Yep.
Because
I would have
think
thought a lesser included would have been where
I
to go.
thought they might go that route, but again, like I said, I guarantee you, the way it went down,
yeah,
they're sitting around that table. I've been back there in the jury room. There's 2 or 3 or maybe 1 holdout, and they tell them, "Listen, here's the deal. I understand there's questions, but we don't have to answer those questions because listen, there's only 2 DNAs on that gun, and 1 was transferred because the kid was shot and it could have transferred on there. The other one, he admitted the gun was in his hand. We have the trajectory evidence, and they probably just completely forgot about what the other guy said, who is the medical examiner, who is
got
more
it wrong.
credible, in my opinion, looking at the wounds. And they said, down, boom, come on, quit wasting our time. And then the person finally probably just said, you know what? Okay. Yeah, I didn't remember that. I must have missed it, but I really have all these questions. Boom.
You just blew their nose.
No, that was my wife.
So, ASMR.
So yeah, listen. So Columbus, just to address Columbus. Listen, here's the problem: unanswered questions
are doubt.
So I'm
right
sorry, you're
Right
delivering. You're saying right now by that statement, you're just not understanding the fact that the burden is on
even
the
if it
state.
didn't go down the way that Steve's saying,
Well,
it's
what
still
we
doubt.
also have to remember. Again, we've gotten down all these rabbit holes, but at the end of the day, the burden is on the state. And as a result, what a lot of people don't understand, Columbus doesn't really have this mindset. But this is the mindset a juror must have. And a lot of jurors don't. But it's when you begin the case, he was presumed innocent. If there's a conflict of evidence that you cannot explain, it breaks for the defendant. If there's a question about that, the state has the obligation to prove its theory of the case beyond a reasonable doubt.
And above all,
without question. End of story. So if there are unanswered questions,
it's doubt.
It's doubt. You can't speculate to get to beyond a reasonable doubt. And that's what this jury was required to do. So there it is. But I understand. Listen, what I don't understand is why like the vilification of the man. Like it doesn't make sense to me. I mean, and really honestly, step back before you move forward and cheer on this for him, because if this is all we need, it comes in many different forms.
Yep.
Car accidents.
Yep.
Accidents at your house. And believe me, you may think today, you're like, I'll never be there. You don't have any control over accidents.
Nope.
And then you don't have any control over whether or not the police believe it wasn't. And
you can have a federal investigation.
Yeah. I mean, listen.
And still.
Listen, when the police decide that you did something and they have millions of dollars to prove it, even in this case, they didn't do a good job. They left a lot of unanswered questions. But it demonstrates that a prosecutor can take that case and argue it to a jury. And
well, that's exactly what Steve Gosney, when he came on, he said that in Florida in particular, a lot of the population down there now is people that are pro the death penalty.
Yeah.
And then you add that to the prosecutorial system that has, unlimited resources and has elected people in to be more biased to prosecution, then you are set. Like,
Yep.
this is the jury
But see,
pool
the
is
thing
tainted
that's
already.
the scary part that people don't understand is like I talk about the presumption of innocence all the time, like it's some finite thing. But the
Yeah,
scary
but they're
part
not
is that
presumed innocent anymore, I
is
don't
that
think.
well they are, but the jury. It's also the concept that the jury is the decider of what's
Mm.
fact. That's what like all those jury instructions are. You get to decide what you like.
Yeah.
You don't like just because a witness lies, the jury, just like Columbus is saying,
Yeah.
and Columbus is doing there. Hey, I'm taking the part. The gun's in the hand.
Yeah.
Everything else is a lie, but I'm okay with that. And then they
But the
come by and they
mindset
say,
is,
and then
will they
they've
be
decided
charged?
that, well, then they've decided that the most credible evidence is that gun
Mm-hmm.
expert that says the trajectory was
Yep.
downward. And once you
Yep.
accept that, gun in hand, downward trajectory,
Mhm.
and then you say, okay, his DNA's on the trigger, his DNA's on the handle. The kid couldn't have been shooting in that direction. Yes, it rules it out. And then you are there at beyond a reasonable doubt. But the problem is that what you're using to get there, that is not what none of it is what it said. It's not actually, even by the testimony that was presented on all of those issues, it's not beyond a reasonable doubt. But the jury is being argued to say, accept this. And you don't have to worry about motive. And you don't have to worry about any of this. Of course, it's up to the defense to make the better argument. They did. They lost. But at the expense, but it should be something that it should give great pause.
Because they
Because
didn't have a defense, is there more grounds for appeal or not? Because they didn't preserve any record, did they?
What's that?
Like, because they didn't put on a defense, does that mean their chances for appeal are
Oh no, they
reduced?
preserved
No?
the appeal is within the judge's rulings and the objections and the evidence that was allowed. So yeah, the lack of putting on, you don't have to put on a defense. So that would not in any way have any bearing on the appeal, because the appeal would have to do with evidence that got to the jury, with limited things that the defense was limited from arguing. And there might be perhaps rulings that the judge made that limited what the defense was going to be able to be put on anyway. So they decided to not go with the defense. So all of that will be examined on appeal. And these lawyers will leave the case because they will, in Florida, they do have a strong belief that you don't let the trial attorneys handle the appeal. Steve Gosney even talked about that. So they will appoint an appellate counsel for him, and then they will go and dig into this case. And look, this case, there is problems in this case. This case, I believe, will be back at some form, at some stage. There will be, it will be relooked in, because this is one that just sticks with you. And yes, Columbus, absolutely, that's what I'm saying. The jury adopted this. 12 people sat in that room and adopted the evidence. So I respect the verdict, but I think at the end of the day, if the jury was able to go back and dig back into the evidence, re-listen to it, and really get into the minutia of it, that those that had doubts would say, oh wow, I really wish I didn't make that. I didn't change.
Well, we've got the ability to go back and listen. They
Go
don't.
back and look and have the entire record
And
in there
analyze
and
and
analyze all of the problems. They remember when you're on a jury, and I sat on a jury. I mean,
it's
so it's all up here, and then you get to take some notes. But you're discouraged from taking notes, because what they really want for you to do is listen to this testimony. And when you're making notes, believe it or not, every time you write something, you're starting to formulate an
create more
opinion,
bias. Yeah.
and you're creating bias. And the next thing you know, you're going down a road
You've made
of
your decision
bias.
before you go into deliberation.
But here's the thing. I don't think most jurors really sit there and go, I'm going to purify my mind. A lot of these jurors, I'm sure, made a decision he was guilty. They make a decision that they're guilty when they see them sitting over there, regardless of the admonitions of the court. And then they start to formulate that bias. And all what happens is it gets confirmed along the way, and they shut down and they miss. Plus, not to mention, I miss some of these things. We were
You can
watching now.
manipulate data to fit any narrative you have.
Yeah, but and it's also the idea too that, like, you're sitting there. These are jurors who have no experience with DNA. They have no experience with police procedures. They have no experience with any of this stuff. and they're sitting there, and all of this is thrown at them. So yeah, it's not exactly surprising
Correct. That's
that we
right.
find out that they're
You
missing things,
summed
just
that
like we
up
missed them.
beautifully.
Yep. What Dean
Summed
said.
it up beautifully.
Yep. Of course, and we respect
The
it.
amount of weight
Absolutely.
that they apply to it is.
No,
has
but
their
I
place.
also respect the process that will continue, and I have faith that in the process that will continue, I think we will see this case back in the news again, maybe even having another
doubt.
trial again, because I think there's more to it. And when you have people who haven't spoken yet, if that you'd be surprised now that obviously this woman cared enough about this man and she was letting him have contact with that child that she might say it's time to speak up. And if JJ knows more, JJ might at some point say, I need to tell what happened.
He'd
And
have to be
I
deemed competent,
believe
though.
we are going to see more on this case as this goes on. Now, will it get him out of prison? Maybe not. Will he ever see the light of day? Maybe not. Would I want to be this man right now heading down the
Hell
Florida
no.
penitentiary? He might not survive. He might not survive long enough because he's got the blood of a five. Was she 3 or 5? I can't remember.
5.
5. Okay. Blood of a 5-year-old girl and the blood of an 8-year-old boy. It isn't going to go well for him. And, it's not a life I would want to be living. I wouldn't want to be living a life ever in prison, but let alone with that there. And it's been broadcast and aired live. He's going to have an X on his back, and they're going to get him. So, but you know what? This is where it is. So, but I believe this case, we will hear about this case again. Hopefully not in the negative for him before this thing gets to work its way through the appellate process, and hopefully at some stage really get to review everything that happened in this 2.5-day trial, and maybe get some answers. But I don't think the answers we were given in this case are anywhere near the truth. That's my opinion. But I respect. I respect the verdict.
And as they say, justice is
a process. That's right. That's right. That's true.
I got you this time.
Yeah,
you missed it last time.
All right. Did I miss it last time? Oh,
yeah,
man,
you didn't.
I did.
I stood there like.
Oh no! Okay, I wasn't on my A game then.
No. All right, the bladder has spoken.
All right. Well,
thank
everyone,
you very much.
Thank you very much.
Again.
Yes, and we will see you in a fortnight. And and onward we go. So we got plenty of other cases and things to watch. In the meantime, yes, everybody be ready for the Chidester case. Hopefully, they will have. They had cameras in there so far every step of the way. I'm sure they will. But that is the Swan Boat Club case out of Michigan.
Killed the 2 kids crashing into the.
Yes, and they were trying to suppress. Let me tell you, that evidentiary hearing was absolutely hilarious with the judge just going after that defense attorney because he didn't even put the stuff in the motion he needed to, and it was like, this is not even in the motion, sir. And it was like, well, I mean, at the preliminary exam, it's like, what are we doing? But it's going to be an interesting case because the defense is going to be that the blood test that says she was drunk is unreliable, and 2, excuse me, and 2, they're going to say that what caused the accident, which again, it's something a lot of people struggle with, is that you have to prove the alcohol caused the accident. So you can be drunk, you can be driving, but if the alcohol did not cause you to have the accident, that is a viable defense to the part about causing the death, which means she would be found not guilty of the unalivings and all that stuff, and she would be guilty of operating her vehicle under influence of alcohol. So there it goes. There was my wife right there that just popped up.
Yeah.
So
I'm out.
No. So
that's Steve, get off.
Yeah, that's exactly right.
Come help me with the kids.
Yes. So all right, guys. Well, with that, we will see you soon. And
we will. Stay tuned.
Until then, let justice prevail.
Night.
For the record. record, come on in. Stories that make your head spin. For the record, come what may. Listen in and have your say. Each and every case and file, each and every court and trial. Listen to our voices true. Each one with